My name is Counselor Eileen Duff from the 5th District. I am your chairperson today, and some of us are remote and some of us are in person because of the pandemic, but we appreciate everyone's participation. First, I will read the letter from the governor. What I'll do, because it's a little bit different, is we'll introduce each counselor, during the hearing. And when it's the nominee's time to speak, if he'd like to, we'd love to have him introduce anybody with him in person or at home in support today. So the letter from the governor, dated September 9th. Dear counselors, I'm pleased to nominate Patrick M. Haggan to the position of Associate Justice of the Superior Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm enclosing the nominee's resume for your convenience. Sincerely, Charles D. Baker. And so with that, we will call your first witness, and I believe that is Judge Michael Dooling. Judge Dooling, would you like to say a few words of support?
I would. Everybody, can you hear me?
Yes, sir.
It's my honor and my pleasure to testify before you today, and it's an honor and pleasure to testify about someone I know very well, candidate Patrick Haggan. I've known Patrick for approximately 25 years. I think I met him on his first day as an attorney working in the DA's office in the Dorchester Court back around 1995. He has remained the same as he was back then, affable. He has absolutely no attitude about him. He's honest, he's decent, he's hardworking. And I've had the pleasure of watching him develop as a trial attorney over the past 25 years. When he was promoted to the Superior Court, I had a chance to try 3 very serious cases against him in the Superior Court. 2 homicides and a assault with intent to murder. He was always calm. His attitude is measured. He's knowledgeable as a trial attorney, well prepared. Again, he's been honest and decent. There has never been an issue of hiding of any evidence, making improper arguments or anything of that nature. He's always maintained a great sense of humor. He's a man of good character, knowledgeable about the law, and very experienced. When I had the honor of being appointed to the court last year, I was going through my 2-week education phase where I sat with other judges in Suffolk County, got to know the other judges a little bit, and they all had a high regard. Pat. I actually had the pleasure of second seating Judge Wilkins during Pat did as a plaintiff's counsel doing a medical malpractice trial. And the skills that he has as a trial attorney, having tried, scores of serious felonies, have now transferred over to the civil world, where he was a very good plaintiff's counsel as well. I know Pat personally as well outside of the courtroom. I've gotten to know his family to some extent over the years. He's a very good family man. He cares very, very deeply about his family and his children. He's a man of great character, integrity, and he has great experience. And I think he'll be, he's a wonderful candidate as he appears before you. And if this board sees fit, I believe that he will be a fine Superior Court judge.
Does anyone have any questions for the judge, for Judge Dooling? Great, thank you. And on that, I would like to introduce our next witness, Miss Eva Mitchell, who was a family member in a case that Attorney handled. Ms. Mitchell?
Hi, thank you very much for introducing me. My name, again, is Eva Mitchell, and I'm going to tell you a short story of why I am testifying. I'm just going to begin and end with the characteristics of former ADA Pat Haggan as being absolutely and 100% characteristics of fairness, ethics, professionalism, and honesty, kindness, compassion, and thoughtfulness, hardworking and attention to detail, and astuteness professionally and personally. The story of the case that I'd like to share with you starts in 1992, but I promise I won't be long. That's when I was a student at Harvard and was part of the largest African American sorority in the United States, Delta Sigma Theta. And my sorority sister, Lena Bruce, who graduated with honors at Tufts University in engineering, the first in their memory to achieve such distinction, was brutally murdered in the South End. As new college graduates, we were horrified not just by the murder. I'm talking about all of the members of my sorority. This is and again, on the local and on the national level, but also on the way that the police at that time handled the crime scene. The crime scene was easy to enter. People were going in and out of the apartment. And of course, we were all concerned that the killer would never, ever be caught. Roll the tape forward to 2014. By then, I was the associate commissioner for an agency in Massachusetts, state agency in Massachusetts. And my line sisters and sorority sisters throughout the chapter were now judges, doctors, district attorneys, all the way from this local area nationally. My founding chapter member, Loretta Lynch, was really, really interested, the former Attorney General, really interested and stood by this case, and we were all watching. And ADA Haggan had no idea at the time how much we were watching this case. But that's when, 2014, the murder was identified as a suspect due to a DNA match. And in concert with the Boston Police Squad, ADA Haggan, by September 2015, had gathered all of the evidence. I would again mention it was a very difficult case to prosecute because of the way the evidence was handled, and had already indicted the suspect for first-degree murder. Now, unfortunately, by then, both of her parents passed away. So did her brothers. There were only two sisters and a brother to contact. Having been from Lena Bruce's family, Lena Bruce did not come from an educated family that felt comfortable in navigating the system. And because their experiences with Boston were at least interpreted in the past around the time of the murder as being uncaring, to say the least, were a little hesitant and called on her sorority sisters, including me, to join the case. Now, at the same time, they were so complimentary of how Pat Haggan handled them with compassion and care from start to finish. They felt like that was a real turnaround. They communicated that to us, and we were so happy to engage in the trial. And matter of fact, when the indictment was scheduled to handle, there were about 50 of us gathered outside the courthouse. Now, it ended up being rescheduled because of the attorney, but we had the head of the NAACP Boston there, that's Tanisha Sullivan, also a member of our sorority, and countless others had flown from out of the state just to be there at that time. Now, roll the tape forward again to October 31, 2017, when the jury was selected. At that time, I was the deputy chief in the mayor of Boston's office, and everyone was still watching this case heavily. We were in constant communication with the family, and we were so impressed at the way that District Attorney Pat Haggan handled the family who didn't have the language to express any of their questions and concerns, but he was so intuitive that he knew exactly how to guide them through the case. Through the trial, which lasted until the conviction on December 17, I don't even think Pat Haggan himself knows how much it was being watched all over the country. So every single day, we had people from different states come and sit in on the trial, at least one attorney at the time, and we debriefed the medical evidence with our doctors that were in our chapter that knew her well as the DAs, assistant DAs, and trial court attorneys that were in our network. And 100%, I can say to you, they were very, very impressed at how he made a case with the evidence, put everything together, and handled the whole set of arguments. After the trial was over, I said to Pat Haggan, on behalf of all of the members of Delta Sigma Theta sorority, some of whom you don't even know, we are so impressed with the way that you handled the evidence, the hard-working nature of your workflow. We were tired showing up in court every day. He was outworking us. Clearly, we were sitting there, and he showed up. We couldn't even tell he was tired. He was completely unflappable. And yet and still, in spite of clearly very little sleep, he couldn't have gotten more than us, and excruciating attention to detail and an eloquence in argument, he was completely kind and thoughtful and patient as we barraged him with questions that came from, again, all over the country so that we could understand how he's handling the case. I should also mention that we were also very impressed with the way in which he measured his words. It was completely perfect in terms of being honest and yet holding this professional standard about what should be shared and how. And using that in a language that helped us understand as professionals, some of which with advanced degrees and a lot of experience in law, and those of us who did not have that experience, and some who didn't even have the benefit of having an education where they could begin to understand what was going on. The degree of astuteness, both professionally and personally, I cannot underestimate. And the way in which he handled a bunch of I have to tell you, those of us that went to Harvard, Tufts, MIT, and Wellesley and Bentley as part of this chapter, we're a bunch of high-strung professional women, not an easy handle group. And before there was this movement of Black Lives Matter, it was very clear to me that for him, all of our lives mattered, all. And I asked him, please, if there's ever an opportunity for me to tell the story, and I feel like I'm not doing it well enough, I could say so much more, but he told me I had to limit my time. I said, good luck with that. Good luck. I would love to tell that story again and again. And he has so many people standing behind him. I'm proud of my state of Massachusetts, for my Commonwealth of Massachusetts, for having the wisdom to nominate Pat Haggan for judgeship. Thank you.
Thank you so much. That was an incredibly powerful and compelling testimony, and we really deeply appreciate it. Thank you for appearing today, and thank you for being a participant in hopefully a good story in the criminal justice system. So now I would like to call on our nominee, Mr. Attorney Haggan. Are you there? And if you'd like to introduce anybody of your family first before you make your statement, please go ahead.
Madam Chair, I think Councilor Devaney had a question.
I'm sorry?
Councilor Devaney was trying to answer this question. Council Devaney is not yet recognized.
Oh, Council Devaney, you wanted to say something? Didn't see that you raised your hand. I'm sorry.
Well, I was waiting for you as the district councilor to call on us if we had.
We've already gone over that, Marilyn. Do you have something to say? Do you have a comment?
I don't see her. Okay, I can't see it. Eva, can you tell me, I don't have any. Can you tell me a little bit about yourself, how long you've been an attorney and who you work for?
Marilyn, I think that I think you're asking a question of the witness of telling us a little bit about herself that I think she's already answered. But if she'd like to give us a brief synopsis, we really do want to get into the hearing. But Ms. Mitchell, would you like to tell us a little bit about yourself?
Sure. What would you all like to know? So
Well,
currently,
I'm not sure what Council Devaney is asking because I thought you pretty much answered that. But
I don't mind. I have a lot more to say.
but we don't want to, and we appreciate that. And to be frank, you're one of the more powerful, compelling witnesses I've heard in 8 years. So,
But we do
but
have the assembly coming up also.
right, but we want to get this moving along. So,
Exactly.
and now Council Devaney has left the room. So actually, I'm going to go back. Attorney Haggan, why don't you introduce the members of your family who are here, and then you can give your statement. And Ms. Mitchell, I apologize. With this new way of doing things, this hybrid system, we get a little turned around at times. Thank you.
Should I stay on, or should I go
Yes,
back to work here?
No, we're gonna let the nominee talk if you don't mind. Let's do that.
Yes.
Thank
Yes,
you. I think the nominee is muted. Can someone unmute him? Chris, no one at home can hear. All right. We can hear you now. Well done, sir. You must be a lawyer.
So, just reintroducing my wife Liz with me, as well as my son Matthew and my daughter Caroline joining us. My mother Judy, and my brothers Terry and Joe.
Okay. Hold the mic just a little bit closer, if you don't mind. Thank you, sir. Perfect.
Okay, I would first like to thank all of you, the governor's counselors, for taking the time to consider my application, to review my materials as provided, and to actually speak to me for a long period of time. Each and every one of you certainly has a great and substantial responsibility to your district and to the Commonwealth as a whole to ensure that you confirm judges who will be unbiased, fair, ethical, and diligent in the discharge of their duties. I would also like to take this moment to thank Governor Baker and Lieutenant Governor Toledo, as well as the Judicial Nominating Commission and the Joint Bar for recommending me for your consideration. It's truly an honor to be before you and to be considered for a role that carries with it such an awesome and crucial responsibility to our fellow citizens. See that justice is done. I would like to introduce my family, who is present, without whom I would certainly not be in front of you. As I mentioned, my wife Lynn is here. She has been so supportive of me throughout my career. When we were best friends in the days off together in the late 1990s and for my entire career. In addition to being there for me, she has made incredible sacrifices to allow me to get to where I am now, especially sacrifices in her own career by working part-time and even taking a number of years off to stay at home during our children's most formative years. She's a smart and talented attorney herself. She's been a sounding board for me, advisor, and oftentimes an editor. She's often been honest, even brutally at times, which is helpful for a trial attorney to have. She helped me become effective and fair at trial and in just about everything that I've done in my life. And to my two amazing children, Matthew, who was 16, and Caroline, who's 14, they both keep us constantly on the phone and laughing all the time. And of course, for many years now, if you don't find Glitter Art at work, you'll certainly find us at a local hockey rink or a baseball field or football field. And it's been a such joy to watch them play sports. And in my son's case, there's practically no sports he hasn't played. Each of my children has grown up knowing that when I've been on trial, and that's since they've been on trial. I think any trial attorney can understand what I'm saying. They've always been understanding and rarely complained about the time I took away from them for my work. So I'm just telling my children that you are my world, and I am so proud to be your dad. Now, although they are here only virtually, I wanted to introduce, recognize, and truly thank my mother, Judy, and my two older brothers, Gary and Joe. My mother recently retired from a local school system in Connecticut, where she served as a library aide for 15 years, and prior to that, she worked as a secretary at General Dynamics for 25 years. My brother Gary is a scientist at Pfizer, and my brother Joe recently retired after decades of service to the state of Connecticut Coal Director of Coal for the state. As a single parent who was always employed full-time, my mother sacrificed so much of herself for my brothers and me. No matter what, family always came first. Was and still an incredible role model. Both she and my brothers, whom I have always looked up to when they weren't torturing me, instilled in me the importance of decency, compassion, integrity, hard work, and a lifelong goal of helping others. Lastly, I want to recognize my mother and father-in-law, who have been there in countless ways over the last 17 years for Lynn, my children, and me. I should also thank my many other friends, colleagues, and relatives who have offered encouragement and who wanted to be here today, but who are listening virtually due to the pandemic. Each and every one of you counselors has before you a packet describing my legal career, my courtroom experience, and significant cases that I handled. But I think it's important at this time that you look beyond that and learn about me as a person. As painful as parts of my life may have been, I feel that my life experiences, as much as my work experiences, have uniquely prepared me to be a judge who will serve honorably, ethically, and with fairness to all who may appear before them. My father grew up in northern Maine and had only a high school diploma. He served in the United States Army and was in Germany in the late 1950s. My mother, the daughter of an Italian baker and nurse, grew up in London, Connecticut. After they met and married, my father's job working for a propane gas company required that our family move frequently in early years. I was born in Rutland, Vermont in 1969. Within a year, my family moved to Wilbraham, Mass., where we lived until I was 4. And then we moved to Waterford, Connecticut for the rest of my childhood and adolescence. Although he was truly a loving and good man in so many ways, my father was also an alcoholic. My parents were divorced when I was in 3rd grade, and I was essentially raised by my single mother. Like many who fall into the throes of alcoholism, my father sadly lost every good job that he had, and although my mother took him back on multiple occasions as he tried to be sober, he inevitably regressed. For most of middle school and high school, my mother literally worked 3 jobs. Yet somehow we, her 3 children, never really wanted for anything. We never got to go on vacations, but we knew that we were the center of the world, and she somehow even scraped together the money to send all 3 of us to private Catholic schools. In April of my senior year, my father died in a fire while smoking and drinking in bed in a trailer that he shared and lived with my grandpa. Although he had not lived with us for many years, he still was a major part of my life, and his death was obviously devastating. I'm telling you this, members of the council. I'm not telling you this to suggest that my childhood and upbringing was better than anyone else's. Rather, I tell you this because I truly understand firsthand the effect addiction can have, not only on the people suffering, but on the many others around them. Likewise, I've also seen firsthand in my professional career the frequency of addiction and substance abuse, major factors in almost all the crimes that come before the court. After graduating from Boston College, I knew that I wanted to go to law school and have a career in public service, where my goal was to help others. What drew me to become a prosecutor was the concept in the case law that I think the jobs correctly was supposed to be administrative justice. A prosecutor, in accordance with their ethical duty, is supposed to seek justice, whatever that may be. I was incredibly fortunate to work with 2 great attorneys, Ralph Martin and Dan Conley. A. Martin hired me and told us very early in training to simply do the right thing. Dan Conley took that a step further in his instructions to do the right thing, the right reasons, in the right way. That meant dismissing cases that arose from an unlawful search. You were to do it. It meant dismissing the very misdemeanor cases that had not to compromise the young person's record of who were supposed to do it. It meant seeking a life sentence in prison for a heinous murder. You were supposed to do it. Dan Conley, being a prosecutor in that office, was never about wins and losses, convictions, or incarcerated sentences. It was always about integrity, ethics, and professionalism. It was about serving the community. It was always about treating everybody, including and especially defendants and defense attorneys, with respect, dignity, and fairness. As you know, I was fortunate and privileged enough to serve the Conley on his leadership team for nearly 15 years. I rose as an unpaid intern in 1993, becoming chief trial counsel in 2005, first assistant in 2011. Nearly every single day of that last 14 years, I made difficult decisions on charges, indictments, sentencing recommendations, breakdowns, cooperation agreements, and dismissals. Every day, I remind myself that I was never dealing with statistics. I remind myself that I was dealing with real people, victims, defendants, witnesses, and neighbors. I was mindful that every decision I made impacted human beings and the community at large, and always at the forefront of my mind, making sure I did my very best to do the right thing, the right reason, and in the right way. I am confident that I would discharge my duty obligation as a Superior Court judge in exactly the same way. Although I am proud of the trials I handled and the closure and justice that I hope I brought many victims' families who suffered from the ultimate loss of homicide, I'm equally proud of the office that I helped build and the reforms that I was part of, including reversing wrongful convictions, sulfatory evidence grading protocols, conviction integrity program, police officer credibility database, full transparency in police involved use of force, as well as mandatory ethics and implicit bias training for all prosecutors. Lastly, I take pride in the fact that I made a difficult decision after 24 years to become a civil litigator with a law firm of Blue Environment. Not an easy decision, but it was the right decision at the right time. It provided me with an incredibly solid foundation in the area of medical malpractice and civil litigation. In just 13 months, I tried 10 cases to report juries as a civil litigator. Lastly, council members, I firmly believe that my career and my life as a whole has prepared me well to serve the community and the Commonwealth Superior Court judge. Thank you again for your consideration and your time and for considering for the privilege to serve in this next step of hopefully my career.
Thank you very, very much. We appreciate that. It was very compelling story. Before we start the questions, I do want to get one elephant in the room out of the way. I know that you have several members of your family that are already in the court system, and there has been a lot of criticism, some of it subtle, some of it not so subtle, about this appointment. And I will be frank and honest. When I saw it, I was one of those people that said, "You got to be kidding me, another?" And then I met you, and then I did my due diligence, and I read your paperwork, and I made the calls. And I have to say, you're an excellent candidate, and you're here on your own merits. You're not here on the merits of your family. You're not here through nepotism and political ties, albeit I'm sure there will be some critics out there who like to run their mouths and will say such. I can say with complete honesty and astuteness that that is not the case. And I want to address it right now because I don't want this hearing to get off the rails talking about things like that when they frankly have nothing to do with your real qualifications and your paperwork and why you're here. I think everybody knows that I will be the first one to make a criticism like that if I think it is real, incredible. And in your case, I have to say I've been proven quite wrong, and it is not a credible criticism, and it is not true. So I just wanted, as the chair of this hearing, to put that on the record. I'd also like to put on the record that I don't get a lot of calls sometimes because I'm not an attorney. I'm a public policy person. I'm more of an organizational development person. So I don't get some of the calls the attorneys get, but I got a lot of calls about you in support. And then we got over a half a dozen letters, and it got to a point where I asked the council secretary just to send them on to all the councils. Those will all be put into the record. I'm not going to belabor this hearing and take time just to run my mouth and read them. But I do want to put on the record that there was a tremendous amount of support from you in the legal community, but also in the community of citizens like Ms. Mitchell, who has come here and really, I think, testified in perhaps one of the most compelling ways I've ever heard anyone as to why you have that intangible quality besides your academics that is a reason for you to help the rest of us as a judge in the Commonwealth and sit on the bench. So I wanted to get that out of the way, and I hope the other councils will abide by my request that we stick to the relevant questions and not get sidetracked with nonsense and political headlines, because that's not what we're here for. So with that said, I will to start the hearing with Councilor Marilyn Devaney, who is the councilor, resides in Watertown. And she is not the dean, but the deaness of the council. And she brings her expertise, and she is the representative from District 3. So, Councilor Devaney, you may begin your questioning.
First of all, I just want to put on the record, I'm allowed to ask a witness a question. And I just want to go through the record your house that we have an assembly at 12. This is what I'm today of this morning. And I want to put up the record. I have some questions. That was it. The other thing is, on the record, I hope that we can get this is not working. You can have anything to do, in and out. And I have to say, people in the same place, we have the in the state house. We are at least 14 feet from the nominee, and we are way past that is required. So this is very difficult, this situation. I like to talk to people. I like to look at you and see it out and well, thank you. And I do want to thank you. You're going to be in my personal book. And I'll tell you what. First of all, past practice, never had on the years, always scheduled at least 2 weeks out. Now, you have a questionnaire to fill out from the governor's office, and it requires you to submit it within 8 days of your hearing. Well, you can't go back to the future. You have to have 6 days or whatever. But the point is, because it's so quick, so fast, and especially the Superior Court, because I like to investigate on talk to us people, I managed to do it. Thanks to you. And you're going to be in my personal corrections because I got your jealousy questionnaire Wednesday, that's what we got your name. And you were so kind to meet me the next day. So I was up till 4 in the morning, going in my going over and over your JSC questionnaire to prepare to meet with you. And I talked to a lot of people, and I have especially said, from the last year. I know you very well, and I'm going to tell you, but you've got 2 better mentors of bosses. Really, I have such respect.
Counselor Duff, I cannot hear her at all.
I know, is that bad? Hang on.
And just to let you know, I cannot hear one word that she's saying.
Okay,
I cannot hear anything whatsoever so you maybe want to talk to the folks
yeah,
here. We can hear,
I just
can hear
texted
you.
them.
I can hear you perfectly. I
Okay.
cannot hear Marilyn at all.
Yeah,
And I couldn't hear the nominee.
I'm sorry, Chris, I'll meet you later and I'll tell you.
Thank you.
Thank you.
But seriously, and I'm trying to talk loud,
Alex.
you know, I want to say one thing up front, and not to embarrass you. I am so pleased with your criminal background. You are replacing a judge who had zero. Okay, zero.
Maybe the
And
mixer,
to me,
but it's, I'm getting audio on the laptop. It doesn't make any sense. If I get audio here, it should go right to YouTube.
you need, with your
All right, they're working on it, Chris.
Thank you.
I'm sorry, it's frustrating. I hope she's actually asking him questions, but I think she's just talking. I don't mean that.
I think you're right.
So this is the computer right here. See this? This microphone? I don't think it's that. This is for the laptop, so I can pick her up if I just use the laptop mic.
Is it bouncing?
Atty, can you hear?
We're ready to continue.
Can I just ask a question? Was anything I said heard by you people? Was it recorded?
Yes, absolutely.
No, I'm talking to technical people here. You have. Okay. So again, as I said, I think it's time with, some of the people who are going. We've got some good people, some not so good judges, but I think the lack of criminal is, I have a theory, okay, in my 21 years here. I'm not a lawyer. I have a feeling if you have not been an attorney and had a legal career of criminal cases, that when you're a judge and you have someone before you, you're going to be timid about sentencing. Now, how do you think about that? Do you agree or disagree?
Well, I would agree that I think one of the most important traits for a judge is to have a trial experience, an actual courtroom experience, absolutely. But I have seen some judges who didn't have that who have done well, but I would agree that it would certainly make it more difficult to discharge your duties as well and as naturally as I would hope somebody with my level of experience.
Now, I'm having trouble hearing you, and I don't know whether that's the microphone or whether it's not close enough or what.
I don't think it amplifies.
But you can hear me.
I can hear you fine.
Okay. Now, I always ask nominees the process of how you got here. So, first of all, it wasn't a slam dunk. You came in 2016 and were rejected. So tell me about that. You went to the JNC. Do you have any memory of how many of the members, 21 members, were there of the Judicial Nominating Commission?
So my recollection, Counselor, was in 2016, I went to the Judicial Nominating Committee. I had a hearing with my recollection, I'd say about 13 of the members, and there were others on a speakerphone in front of me. And just to clarify, I was nominated, I was approved by the Judicial Nominating Committee.
But not the governor.
Correct. Right.
Yeah, no, I knew that. I was going to say that.
Okay.
So in other words, there was at least 8 of those members who did not see you, didn't come to the hearing, didn't talk with you, and voted no. Okay? So it's because they recommend to the governor.
I think you said voted no, though. Is that?
No, they didn't carry you on well, they did vote yes. Okay, so 13 voted yes. Okay, no, 21 voted, but 13 were present.
Well, there could be more than 13, Counselor, because they had the speakerphone on, and my understanding was that the remaining
Well, I'm going to tell you something. I'm here long enough. There was a JNC chair, and he would say to those 21 members, and if people don't know, the Judicial Nominating Commission has more authority than any governor's council. They choose who they're going to interview or who they're not going to interview, and then they choose one person and recommend that person to the governor, and that person comes before the council for a hearing and a vote. So we're not told how many applied, how many interviewed. We only have one person. Yet we have a commission, and most times it's 8 or 10 that are present out of the 21. And so you got 12, 13 people that are voting for someone they never saw, never heard, or anything, giving a lifetime position. So that concerns me. And it has nothing to do with what you can do or not do, and I can't do anything about it either. But I just want to tell you for the record, there was a JNC chair, Judicial Nominating Committee chair, and he said to those 21 attorneys that have the most awesome responsibility to recommend someone for a life position, and he told them, each of them, if you don't come to the nominees hearing, you don't vote on the nominee. Boy, I wish we still had that. That was.
Counselor, can you start the actual question?
Excuse me, this is my time, please. I don't interrupt. I did not interrupt you, and now I want.
This is my hearing.
Thank you.
Now running
Thank
it.
you very much.
Please continue.
So anyway, what I want to ask about is you've had a a lot of profile cases, okay? And you know what really amazed me is the cold cases. Now, how do you choose what cold, because there's so many, and how do you choose? I was really fascinated by the Boston Strangler. I mean, that goes back to, I don't know, 1965, 66, and there was no DNA in those days. And it was just incredible how that was chosen, because I remember reading all about that. And even the victim, Mary, was her last name?
Sullivan.
Yeah, even her family thought that he was innocent. They did, until you got the cold case, you know, and he got murdered in prison, didn't he?
He did.
Yeah. So tell me, how did that come about? And there was a nephew involved that you had his DNA in addition. Now, how isn't that deteriorated from 1965, the Boston Strangler's DNA?
Well, that particular case, I have to give 99.9% of the credit to an amazing chemist in the Boston Police Department who later became director of the crime laboratory. What he had done, and he actually had been working in the unit way back in I think the 70s. So he was aware of the evidence that we had. He was aware that they had biological materials from the rapist and killer, the Boston Strangler. And over the years, as technology improved, he would take a little bit and send it out and try it, knowing full well that it's destructive testing. And once it's gone, it could never come back. And he was amazing in the way he kept trying and trying and trying and always saved a little bit until the very end when they had the DNA technology to get familial DNA based upon relatives of only male DNA, STR testing. And they managed to send it out and determining they had a male profile for the DNA. And then they managed to get some DNA from a nephew that they were able to link to a very, very high percentage as a match to the killer's DNA.
That's an amazing thing. Have you had many cold cases?
Yes, I've had quite a few.
Yeah. Again, I want to get back. You had your hearing, and tell me when you applied and when you went before the JNC and how many were present.
Okay, so in 2018, my best recollection would be the fall, I think October-ish or November of 2016. I went before the Judicial Nominating Committee. Like I said, I recall about 12, 13 people at the table and then an unknown number on the phone. I think within a month, I was told that I was in a due diligence process. I believe I then was told that I passed the due diligence process and the JNC had voted to send me to the governor's office. I recall sometime in around 2017 meeting with legal counsel for the governor, and then after that being told that my name was forwarded to the joint bar. It was my understanding that I did get out of the joint bar after a vote, and then I was eventually told, I think probably in the early summer of 2018, that my application had expired in essence on the governor's desk.
18 months had expired, yeah.
Yes, that's my best recollection. I don't know exact dates.
Yeah.
And
so
then,
how many were there this time?
I'm sorry?
How many of the JNC were there this time, did you say?
Oh, no, are you talking about the second time?
This time.
Well, this time I did not go back to the JNC. The JNC used all of my prior materials and said that somehow I was within the time period where they could vote based upon my prior interview materials. So I did not go back to the JNC.
Oh, you didn't go back?
I did not.
Okay. So what did you do? They sent you a letter, or how did you know?
I had to resubmit an entire application, and that was, I believe, in the October of 2018. And I resubmitted everything, and then again received the letter that they had.
So you go before the governor again, the lieutenant
Correct.
governor, and
governor's
the
legal counsel, and then I
Okay.
believe I went to the joint bar. Is my
Okay,
understanding.
that's good. The thing is that I have to tell you, and I want to compliment you. I've been looking at these resumes, questionnaires for 21 years, and I always ask, and my colleagues will tell you, what's the rest of the story? What happened to this person? What was the sentence? First time, I didn't have to do it. You can write, and I think on the Superior Court especially, you need a judge that can write and write the decisions and be able to say why you acted that way. And I like that. And you're thorough. I mean, I read every one. couple made me cry. And I want to tell you, the one that did, when we met, I saw your compassion. That I felt it when I was 3 o'clock in the morning reading it, and when I met you and we talked about it. That horrific case about the 21-year-old mother that was missing. And they found her, she was murdered, but they never found her 3-year-old boy. And when the police went into the apartment of her ex-boyfriend, father of the 3-year-old, and his new girlfriend, he threw the trash bag out the window that contained the little boy and all the garbage. That made me cry. And you felt it. And I remember you saying, and I want to say it, your son Matthew was 3 years old at the time, when you had to hold up those pajamas that were the same as he had with the footballs on it. I don't know how you do it. I mean, I cry at parades. I'd be no good at that. So those are the, was that one of your, the most, how can I say, pleasant results for you to see justice done with that? And then on top of it all, this father and his girlfriend killed the woman and her son because he didn't want to pay child support. What kind of monsters do we have, really? And you've been in how many cases like that? I'm sure. Was that one of the worst that you went through?
Yes, I think that was one of the worst I've handled.
What about Aaron Hernandez? That was a couple of months, wasn't it? You had to go through that?
I believe we started, yes, on February 14th, and the verdict came back April 15th or thereabouts.
How does that happen that you get chosen for that? You must have had a good record that they chose you to take on a case like that, right?
Actually, no. Those of us who handled murder investigations in the Suffolk DA's office, we would get assigned cases as they came in. And I remember very well getting a call at about 3 o'clock in the morning that there had been a double murder down in the theater district of Boston. And the chief of homicide asked if I would take the case. And I said, absolutely. I just finished a murder trial shortly before that. I remember going to the crime scene. I remember seeing those two men murdered, that they kept them in the car, took them to the evidence bay at Boston Police Department. And I kept the case from that moment on. We had no idea of the possible connection to Aaron Hernandez. And I worked that case from that early morning until the conclusion of the case and never stopped working.
Now, what happens in a case like that when he is convicted and then he commits suicide in prison? How is that determined, that case?
Well, it went up to the Supreme Judicial Court. There was also a push for legislation. You probably recall there was a lot of legislation and a lot of press conferences about whether his conviction, the current state of the law back then was that it was voided by his death because there was an appeal pending. But I believe, if my memory is correct, the Supreme Judicial Court did then reinstate the conviction and said that the reading of the statute wasn't as it appeared to be. So that conviction is still not valid.
Tell me, what's your opinion about time standards?
Well, I get it. I think the purpose behind them is valid and noble. You want to have a judicial system that's efficient, and you want the public to have faith in the judicial system. But I think time standards should never take the place of justice and never take the place of recognizing that the people before you are human beings and hardworking attorneys. And I think as a judge, if I'm lucky enough to be confirmed, I would always remember that. And I would not make decisions based on time standards when there are parties before me who are presenting valid reasons why the case needs to be continued.
Okay, I'm going to ask you questions about your personal philosophy, okay? How did you vote on the marijuana question on the ballot?
I believe I voted against it because I was concerned whether or not it would be a gateway drug, and I just knew that there was a lot of crime that was oftentimes involved with marijuana use, and particularly marijuana sales. We had some very high-profile murders that were involved with marijuana dealing, including the quadruple homicide in Mattapan that was termed the Mattapan Massacre. That was related to marijuana sales. that was my opinion at the time. That being said, I think, some of the research that's been done out in Colorado and other states that had legalized marijuana prior to Massachusetts, and with the way it's being handled right now in Massachusetts, I believe my opinion may have been wrong on that. I think there has not been as much of an issue, an increase in crime that I thought there would be, and an increase, quite frankly, in addiction. I'm always worried about something, increasing addiction.
Yeah, I'm for medical marijuana, but I voted no also. And there's no proof that it's gateway, but for me personally, I have two close friends, Kate and Francis, who lost sons overdosing on heroin, and that's how they started. Okay, now you have had involved in juvenile crime. Okay, so what is your opinion about extending the age in juvenile court?
It's tricky. I see both sides. I would really just rely on the science. I mean, I think, quite frankly, the reason why we extended the age initially to 18 is because the science was pretty clear that a juvenile's brain development, it's not developed enough at 16 or 17 to make the valid choices and to be able to form the type of intent that is involved in most crimes. So certainly in reviewing that research, I agreed with lengthening the age or making a juvenile age limit go up to 18. I'd like to see the research now about moving it up further, but it's something I recognize both sides to the coin, but I'm going to rely on data and scientists more than anything on that.
Well, I mean, I think I'm preaching to the choir, but we've had a lot of juveniles who have had, egregious rapes and murders. And so my feeling is, a layperson, that I just think, number one, juvenile court is overworked enough, and that, to have more coming in. But my other thing is that a juvenile doesn't get the sentence as an adult if they went before you, right? I don't think they can give a stronger sentence.
Well, you can. There's the youthful offender statute that is in place. So someone is indicted as a youthful offender. They are, in fact, indicted, and they can get both a combination of a juvenile sentence with a criminal penalty afterwards. They can actually get state prison time following their turning of 18. So you can give a juvenile an adult sentence based on the current state of the law.
Right. Well, I am impressed with all your publications and all the things that you've been involved in, and you certainly have, covered all of the thing is that, another thing is, I believe in life experience, and you have the age and the life experience that you're bringing. And, in your own, that you mentioned, your own personal life, you weren't born with a silver spoon in your mouth, and it must have been traumatic as a little boy to have your mom and dad break up. And I your mother is very special to be able to, bring up a family by herself, especially in those days. I mean, it wasn't the thing to do, all alone. But so when did you decide that you thought you would be a judge? Is there something in your mind that you always said, that's my goal, when you first became a lawyer, or what was it?
I think pretty early on in my legal career, I appeared in front of so many judges who I had the utmost respect for and who I was so impressed with. And starting from that premise that I wanted to be in public service, that I wanted to serve the community, I quickly realized that the highest calling in the legal profession to serve the community and to try to do the right thing is to become a judge. So I think I really had that aspiration very early in my career, and I can't credit enough the many excellent judges I appeared in front of over the years.
So okay, tell me about, what I didn't understand, and you could tell me, the Conviction Integrity Program.
Yes.
Tell me about that, because I have never heard of it.
Sure. I was extremely proud to be part of the first Conviction Integrity Program in the entire state of Massachusetts, and I think it was the first in New England. I'd need to check that. But it essentially reviews convictions that our office has done, and there's no time limit. We looked at cases from the 1960s. We looked at cases in the 1970s where there was a claim of actual innocence, and we would, as a committee, look into the case. It would oftentimes be started by a defense attorney requests for DNA testing and the like, but we would affirmatively pull those cases and then reassess them, reevaluate them. We would try to make sure that anybody who was involved in the actual case was not allowed to be on the committee, but that person or persons would testify before our Conviction Integrity Committee. We would allow the defense attorney to come forward. We would get members of the Boston Police Department cold case unit who had no prior involvement in the case to avoid any bias, do reinvestigation, re-interview witnesses and the like. And there were a couple cases I recall that we actually affirmatively agreed to motions for new trial and then null pros the case.
Okay, can you tell us what issuing a Brady and Giglio means?
Sure. So Brady is just the federal case that refers to a prosecutor's obligation to turn over exculpatory evidence. Giglio is a very similar case, and those who practice in federal court know that a Giglio matter is essentially if the police officer witness has something in their background that would affect his or her credibility. And in the federal courts for many, many years, they affirmatively would ask every single police officer whether or not they had ever had an internal disciplinary issue or a charge of a crime of any type, or had ever been determined to be not credible by a court of any jurisdiction. So that was what we saw in our office as something that was missing in the state system. There's nothing like that. So we affirmatively started a Giglio database where if a judge found a police officer not credible, we would affirmatively disclose that to defense attorneys. If a police officer, law enforcement officer had a criminal offense of any type, even a misdemeanor, we would disclose that as well. And the Brady policy was just a restating and having extensive training with our prosecutors to remind them what Brady means, what exculpatory evidence means. And we had a presumptive discovery policy, which we basically told our young prosecutors and all of our prosecutors, look, you turn it over. And if you're not turning something over that's in your file, you better have a pretty good reason not to turn it over. So it was a presumptive discovery policy as well, which I'm very proud of.
That's the first time I've ever seen it in any questionnaire. Is that something new, or is it something that people aren't involved in, other attorneys?
I think most of the DA's offices now in Massachusetts and across the country are doing it, but I do think we were one of the first. Again, I'm proud of that. I don't know the exact stats, and I don't know if somebody else in another state may have done it, but.
How many years have you been practicing now? 28?
Well, I was sworn in 1994, so I
Okay,
believe.
so in
25.
those years, tell me how it's changed, how drug addiction has come into a lot of the crimes that you have covered in those years.
Well, it's always been there. I think if even looking back to my earliest days, it was always there, but I don't think the public and the judicial system quite recognized how big of a problem it was. And I've seen, unfortunately and tragically, waves over time. And for instance, when I was the assistant district attorney covering South Boston back in the mid 1990s, there was a huge spike in heroin overdoses and suicides, and it made the news, obviously, and it was really, really a problem in that community. It then seemed to die down a little bit, but what we see is a continual process where overdoses are just going through the roof now. And I think, I could talk for hours about how that may have happened with the pharmaceutical companies and the like, but obviously right now we have an opioid crisis across this country that is unlike anything I've ever seen before or could have even contemplated.
If you drive by Newton Wellesley Hospital, they have flags, red, green, all different colors. And there's 2,015 of them. And that's how many opioid deaths, overdose on opioids. And I'll tell you, when you go by that, it takes your breath away to see it, really. Now, you've had many cases that have that criminal has got life without parole. Now, tell me, how does that, I know it differs the crime, how some of them we won't even talk about, the ones you've had that are so egregious, but the one that Alexander Callahan that was in prison, and that ended up to be second degree. Now, how did that get to be second degree when you knew he killed him, you knew he killed the other inmate, and they had all the evidence, all the bloody clothes and all of that. How does that get to be, can you explain that to us, how it should be a second degree murder?
Sure, absolutely. So we prided ourselves in Suffolk County DA's office when I was there of always actually analyzing the case and the evidence as it came out in the grand jury and never trying our very best to never overcharge a case. simply for leverage or something improper like that. And as heinous and horrible as that killing was, the evidence in the grand jury did suggest that it was some mutual combat, that the decedent, Mr. Callahan, was much younger than Mr. Jurzik, and it was combat where we could prove basically the elements of second-degree murder, but we could not prove deliberate premeditation or extreme atrocity or cruelty or felony murder, which are the only prerequisites to get you to first degree. So I think we properly charged it as second degree because we could prove intent to kill, we could prove intent to inflict grievous bodily injury, and we charged it as second. And interestingly enough, the jury in that case, where we had a 2-week trial, Mr. Jurzik himself testified, they found him guilty of voluntary manslaughter. So they actually found him guilty of a lesser crime than we had indicted him on.
Wow, that was really something, wasn't it? Huh? I couldn't believe how, how deceptive he was about that whole thing, But so, what is the longest trial you had? Is it 2 months that you
Yes, I believe the 4 co-defendant trial of the murder of Io Nakwe. She was murdered back in November of 2001. We tried the case in 2005. And that case, at that point, was the longest case, I think, in Suffolk County history. I actually tried that case with now Judge Doolin. He represented one of the defendants, and that took about 2 months.
I want to tell you that. Now, what do you think about the specialty courts? I've gone to see some of them because I wondered how much weight they really had. What do you think about drug courts?
I think it depends, obviously, who is running the drug courts and the like, but I think they've been very successful. I would also cite some of the specialty courts in Suffolk County, the homeless court, the veterans court. And again, they're run by exceptional judges like Judge Kathleen Coffey out in West Roxbury. And I think those courts have been remarkably successful, in my opinion. And I think drug courts as well, the ones I've seen, and I remember the very first drug court with Judge Robert Zimian back in the early mid-90s. And he was tremendous at running the court. So I think if they're run correctly and well by a very good judge and a very good supporting staff of probation officers and the like, I think they're very effective.
Well, I have to tell you, well, first of all, I want to tell you that Judge Machera called me. And he, of course, I have such respect for that man. He said a lot of great things about you. He has great respect for you. But I went to, he has drug courts. I've gone to them. And I went to the graduation for a drug court, and I was glad in the back because I didn't have any Kleenex, and it touched my heart to hear these people come up who were drug addicted and told how the drug court and what they went through to rehabilitate themselves. It was in all ages, young girls to older men, and it really made an impression on me to know that, yeah, it works. I don't know, for some people it doesn't, but for those people that were there, I'll tell you, it was really something. So I think I think I covered just about everything that I wanted to ask you. It was a pleasure. Oh, and I know, but for the record, how many trials approximately have you had?
We're about 100, I would say. Okay. I believe it in 30 murder trials and 10 Superior Court civil trials, and then another.
Well, this council sent someone up to Superior Court with 6. Not with my vote, but 6. I can't tell you. I mean, what you bring in your background, and I think today it's needed. It's a terrible thing when you have mothers killing their children and fathers throwing them in bags. It just breaks my heart. I don't know how you do it. I don't know how you can do it and come home and, it's part of your day. So I thank you for all the time that you spent with me. And I was glad that they were open because they opened up about a month ago. So it's nice to get back there. And so I thank you for, everything that you have brought to council with your experience. Thank you very much.
Thank you very much, Councilor.
I think you should pull the mic a little closer to you. I'm not sure.
Thank you. Councilor Steubenville, would you like to go next?
Hear me?
Yes. Can someone unmute him? Councilor Jubenville, yes, we can hear you now.
Thank you. Good morning, Pat Haggan. How are you?
Good morning, Councilor Jubenville. How are you?
It's a pleasure to see you here, and I have absolutely no questions about your qualifications. You have been in the trenches for many years, and Judge Hennessy says one of the best things a judge nominee can have is experience, and you have that in spades. So that's not even an issue with me. I do have some questions for you, and none of how you answer will affect the way I'm going to vote for you. So don't worry about that.
Thank you.
I have received a lot of calls and I don't know, sort of criticisms about, the history, the Brennan history with judges. And my comments to those folks were, look, I'm voting on this man based on his qualifications, not on whatever some governor did nominating a member of the Brennan family. It has nothing to do with me. And so I'm not even going to question that. I'm going to decide, which I have decided, but I tell them I decided based on your qualifications, which are tremendous. So you're going into a new field as a judge, and you're going to be able to separate your many years as a district attorney and a prosecutor from being on one side or the other in a courtroom?
I believe I will.
I can't hear you.
I said absolutely. I believe that I will be able to. Yes, absolutely.
Okay. So there was a study that was commissioned by our chief judge, who tragically passed away, at the Harvard Law School regarding the issue of minorities being sentenced more harshly into longer sentences than non-minorities. Are you familiar with that at all? Did you hear anything about that?
Most of it. Yes, I am. I've read most of the report.
Okay. What do you think about it?
It was extremely troubling, quite frankly, to see that type of data. But I think in the long run, it's going to make our judicial system, and quite frankly, every participant in our judicial system, that much better. Because to me, the report was excellent in that it wasn't just bare bones statistics that they had back in 2014, but it was actually analysis that accounted for things like criminal history and background, and still came up with racial disparities, which, as I mentioned, I think is really a call to action for all of us to really be better at what we do, whether it's attorneys knowing what to argue, or prosecutors knowing how to fairly and appropriately charge cases and make recommendations, and ultimately as judges in really looking closely and asking uncomfortable questions of yourself and trying to, again, make sure that the criminal justice system handles everybody with fairness. Again, it was discouraging to read, but like I said, I think there'll be a real positive from that report. And I look forward to further data. As you may recall, Counselor, the report itself talked about some of the limitations and the lack of data that could, I guess the one thing I would say that was missing from the report for me is why is this happening and what can we do to address it? And in fairness to the writers of the report, they couldn't do that based on the data. So I look forward to this just being the start of making our system better.
Yeah, I agree. I think it's only going to get better if people in the system, especially judges, because they do the sentencing, and until they read the report and decide to do something about it and to have that in their minds when they're taking recommendations for sentencing, if they don't, nothing's going to change. Do you have any idea, being in the court so long, why you think that minorities seem to get sentenced more harshly than non-minorities?
I think if I knew the answer to that question, I would be very wise, and hopefully I would have helped solve it through the legislature and others. But, certainly there's some reason, and I don't know exactly why, but I suspect that it is potentially implicit bias where, again, well-meaning individuals of all the stakeholders in the judicial system, judges, defense attorneys, prosecutors, they don't realize that they're making a judgment on somebody in some small way based upon ultimately what comes out to a racially unfair reason. So I think that there was potentially implicit bias and that could lead to the disparities that we see. But I don't know the answer. I mean, a lot of my theories are pure conjecture just based on my experience.
Well, I've been sitting in courts for 42 years, and I think it has dawned on me that when people of color that live in neighborhoods of color interact with police more than, let's say, a white kid interacts with police in the town of Wellesley, and with more interaction between the citizens in those areas with the police, it's much more likely that minorities are going to get arrested and charged with crimes. And it is, I think, in my opinion, based on what I've seen, when I represent somebody of color who's from certain areas of the city, and they're 20 or 25 years of age and they don't have a criminal record, that is a rarity. Most of the time, they have a criminal record. And I'm just speculating it has something to do with the interactions with police and the fact that police seem to arrest more in those areas than they do in other areas. So when that kid comes before the court and you as a judge are sitting there and, whether he makes an admission or he's found guilty, you decide on what sentence to give him, you invariably look at his prior record. And his prior record is going to contain all of those things that have happened to him in those areas where if the case is one out of some other community, the individual probably doesn't have a record or has a minor record. So the minority candidate with the record gets sentenced more harshly because of that record than the person in, let's say, Wellesley who doesn't have that interaction. You think that has something to do with why the sentences are heavier for minorities?
I think that's absolutely a valid point, absolutely. And I wonder what the best way to address that is. Because again, you have to weigh someone's criminal history, their background. But as you point out, obviously, if based upon where they grew up, if they're more likely to have a criminal record just based on that fact, it's something we need to explore.
Well, here's a thought. And I know we have been looking at records for years. We look at records. It's like a knee-jerk reaction in the courtrooms, right? But at sentencing, let me suggest to you, why do you have to look at a record? You've got somebody before you who's either admitted or found guilty of the crime before you. And we like to say that those who commit crimes and serve their sentence, whatever it is, have paid their debt to society. But it seems to me, and I've just sort of come to this conclusion lately, it seems to me they haven't finished paying their debt to society because we're going to use it against them in a courtroom again. So just philosophically, why do you have to look at a record to sentence somebody?
Well, I would almost pose it the opposite, Counselor Gibbonville. If you had a client who had a completely clean record for 35 years and was an upstanding citizen, certainly you would want to convey that to the court as to why that individual deserved a certain sentence that you were advocating. I think, again, as judges and prosecutors and serving the community, what that person has done in the past and whether or not they've been given opportunities to correct whatever is causing them to violate the law, that's a relevant factor. And again, you raised some valid points as to why maybe it shouldn't be as much of a factor as it oftentimes is. I just think you have to consider somebody's background, their criminal history in sentencing. It's one of the crucial things that you have to look at.
Well, I thought so too, up until 4 or 5 months ago. Now I don't know whether it's important. And I don't think it would be harmful to our system in the courts to not look at records. Just sentence somebody on what they've done or pled to or been found guilty of, and see how that works. Maybe we'll reduce that high level of incarceration of minorities. So if you're going to be a judge, be a bold judge. Think of different ways to do things. We've been doing things the court system never changes. It takes so much to change every little thing in the court system. It goes on for generations. And then somebody comes up with an idea and you go, why didn't we always do it that way? Why didn't we change this a long time ago? So anyway, I throw that out to you to give that some consideration when you're sitting up on the bench. Do you think the war on drugs has been successful?
That's a very tough question. I understand the arguments both ways. I mean, anecdotally, when you compare the level of violence back in the 1980s to what it reduced to back into the 2000s to today, one could argue that it was successful, but I don't think it was overall successful because I think there were too many unfair sentences that were given to individuals during the war on drugs. So, I think statistics can be skewed for either argument. So again, it's a very, very difficult question. I think you'd have to partially define what you mean by success. Again, if success is simply, has there been a reduction in crime? Yes, of violent crime, but can you tie all of that to the war on drugs? Probably not. There are a lot of other demographic and other factors involved. So it's a very difficult question. I think it's a complex answer.
Well, we've been fighting it for 50 years this year. And we've spent, I'm going to guess, billions and billions of dollars. We have incarcerated millions and millions of people. And we see constantly new arrests for drugs, new prosecutions for drugs. It seems to me we have not even put a dent in the drugs. And yet we keep doing it under the same ways we've always done it. I think it's time to raise the white flag and say, we did it wrong, it didn't work, we should try another approach. Let me ask you about sentencing guidelines. Do you know anything about them?
I do.
What do you think of them?
I used them back when I was a prosecutor. Obviously, I didn't use them. We had them, but it was pretty unclear where they came from, how they were established, and quite frankly, there was complete inconsistency how, if at all, they were used. They would typically be used by one side or the other if it helped their case, I think. And I'm more in favor of judges exercising individualized sentencing, exercising discretion, rather than sentencing guidelines that seem to be strict and not flexible. And again, I guess I'd have more faith in the sentencing guidelines if I knew exactly where they came from and what factors were considered to come out with the ranges for sentences.
Well, I like the answer. I too don't know how this group of people sat down and were able to decide a certain crime and a certain punishment would fit that crime. I have no idea. And to think of what the federal court did with guidelines for almost 25 years, the draconian sentences that came out of that court under those guidelines, and the unfairness to citizens of the United States and our Commonwealth. And to think that we would adopt them now after the damage we've seen done in that court, when we had a good system of sentencing. The legislature tells you what the sentencing range is. Legislators vote on it. It's done out in the open. whoever did these guidelines, I never heard of them. I don't know who's on the committee. I don't know where they do it, in secret somewhere. I guess it's got to be secret because we don't want to let anybody know how we got to that point. So I like your answer. The problem is, as you know, if it's good for the prosecutor, they use them. If it's good for the defense lawyer, we use them. And unfortunately, it starts the range in a judge's mind. You know, the guidelines say, I'm making so 5 years. So it seems to be with some judges, well, that's where we start and go down from there or whatever. So I don't think they should be even discussed in the courtroom. And that's my view anyway. But let me ask you, on some courts I know I go to, and I fill out let's say a plea sheet, or I make a plea, I'm going to make a recommendation on a plea. And some courts make me go to the probation department to have them agree on it. Have you ever heard anything about that?
To agree to the plea that you're tendering?
That they have to agree to it before I can give it to a judge and argue.
I have never heard of that before.
Okay, well, it's around. I was in the court last week where it happened again, but I've had it in other courts. And I don't know whether it's coming or it's going to end up in the Superior Court. I don't know. But my concern with it is, you go down to probation. Now, the client, let's say I represent a client who's not on probation. So I tender my plea. The DA puts his recommendation. I put mine. The clerk says, oh, you got to take that down to probation, and they've got to okay it. And I say, why? Well, because that's what the rules said. And I said, what rule? And they said to me, some rule 6. I haven't looked it up yet. But I said, well, why do they have a say in it? They don't know my client. They've never spoken to my client. They don't know the file. They haven't read the police report. They haven't spoken to the DA. And they get to make a recommendation? So I just point that out to you, that I don't know if you said you never heard of it, but it's out there anyway. So, so you've heard the term judge shopping? Yes?
Yes.
Okay. So it doesn't apply to you, because when you're on the bench, I'm going to try to shop to get to your courtroom. But what do you think of it?
Well, I think it's a concern, and that's oftentimes the argument that is used by proponents of mandatory minimums and proponents of sentencing guidelines. It's the whole argument that people can judge shop. So again, I think if most judges are relatively consistent in their approach and analysis, that there'd be no need to judge shop. So I think it's a valid issue.
Well, I do not. I don't know what it means. And very, very limited ability to get before a certain judge. It's almost impossible for me to know, when I mark up my case for a trial, I'll come back in a month or 2 or 3. I have no idea what judge is going to be sitting in that courtroom on that day. I mean, I know they have a monthly list, so you can get a range of a month. But even then, if you go in, that judge that's on the list may not be in that courtroom that day. That judge may be on a vacation day. So to think that you can somehow shop for judges, I think is kind of overblown, and it's one of those conspiracies that the defense lawyer is always up to something. And there's lawyers, and there are judges who, quite frankly, think that way. And I'm going to say to you that at least three, if not 4, Supreme Judicial Court judges that are sitting on the bench today, and I can probably name them for you, testified in an open session of this governor's council that it would be malpractice and ineffective assistance of counsel for any lawyer not to try to get their case before a judge who they thought was fair. So that's what they thought about it. And I certainly don't want to commit malpractice.
Agree with that. I think you should.
So why would I ever want my client to go before a judge, let's say, and I jury waive it, who has never said not guilty in his entire judicial career?
Well, I agree. That would be malpractice, that situation. Again, I think the key is to be in front of a judge who's fair. I fully agree with that.
Well, that's why you're going on to be one that is going to be fair. So we can get some more fair people on the bench. Let me ask you another issue about, this happened to me recently. You're familiar with grand juries? Okay. You're familiar with probable cause hearing?
Yes. They understand exist nowadays.
When was the last time you ever did a probable cause hearing?
I cannot remember a probable cause hearing being done for many years.
The last one I had was about 18 years ago in Worcester County, and it's because the DA's office didn't want to indict the guy, so they let a judge decide the case. But I very recently had an issue where you go into the district court, probable cause hearing, DA says, not ready, judge, I need more time, the grand jury's not showing up, they're whatever. And they get it two times, 3 times sometimes, 4 times. I had one out in Western Mass, 5 times a judge continued the case for probable cause. And the woman was held on $1 million bail. And then they never indicted her in the end. So it's my theory now, since we used to have them a lot when I first started, and you'd bring a stenographer to the hearing room, and you'd have witnesses, cross-examine them, so on and so forth. It is now my theory that no DA wants anything to do with probable cause hearings. Agree?
I agree.
They do not want to put any witness on the stand to be cross-examined under oath before it gets to the grand jury.
Correct. They're seeking to have that witness testify just once before the grand jury, not another time and subject to cross-examination in a probable cause hearing.
So why do we have things marked up for probable cause hearings? We're never going to have them.
That's a very good question. I think, in fairness, and I can't remember the name of the case, Counselor, you may remember it, but the SJC tried to address it with a case that came down about 7 years ago that talked about the proper reasons for a continuance on probable cause, and it did raise the standard a little bit because before that, as you know, it was the kind of standard to get continuances for probable cause hearings.
And what I don't get about it, and I argued to this judge about it, it doesn't matter whether the judge finds probable cause or not. They're going to indict the guy anyway, right? So we go through this charade in these courtrooms every day, knowing that the DA is never going to have a probable cause hearing. So anyway, let me get that off my chest. Have you heard of Alfred, please?
I have.
What do you think of those?
I think it's very difficult, but I do think there could be situations where it's warranted or proper. Most judges don't want to do them for whatever reason. Most prosecutors don't want to agree to them because, again, it's an individual not accepting responsibility for committing the crime and instead just admitting that there's sufficient evidence to find them guilty. But looking at it kind of common sense wise, think about your average district court case when you admit to sufficient facts for a finding of guilty on the plea where you're seeking continuance without finding. That's in essence an Alfred plea. So there could be situations, I think, where an Alfred plea could be considered where a defendant maintains his innocence but yet acknowledges that there's enough evidence to find him or her guilty. But I think it's just an uncomfortable thing for those of us in the judicial system because, again, you're sentencing somebody who's not admitting that they're in fact guilty. So it's something I've kind of gone back and forth with over the years and thought in the back of my mind of situations where it could be appropriate, but it's a difficult issue.
Well, let me just say that in my view, when somebody is going to plead, isn't the fact that he's pleading is accepting responsibility?
Yes, to some extent, but if it's an Alford plea or in addition to sufficient facts for a finding of guilty, they're not admitting they did it. They're admitting that there's enough evidence to prove that they did it. And I know it's a nuance that only those of us in the law fully understand, but it is a fact, and it's something that, does give some people discomfort.
Well, I don't understand the need to have people confess before judges. Reminds me of my Catholic upbringing, where I had to go into the confessional booths every Saturday and confess to my wrongdoing. And I'm sure there was a lot of wrongdoing, but a lot of times I quite frankly lied to the priest about what I did. So he'd only give me 10 Hail Marys rather than 30. And I think there are, unfortunately, in our system, there is no way to resolve a case where a defendant is charged with a crime and he says, I didn't do it. And we know that juries get it wrong about 15% of the time. We know that. We know people have suffered in prisons for long periods of time that they didn't do the crime, that DNA freed them from it. So to me, if you're in a situation, and I have been, and you probably have too, where a client says, look, I didn't do this crime. And I say to him, that's fine. But the only way out of this for you is to go to trial. The DA wants X amount of time in prison. So the only way out is trial. So we're forcing somebody to either get up on the stand and lie to the judge about they did it, so they cannot get the heavy sentence, to commit perjury. And it happens, I'll suggest, every day in this Commonwealth in one court or another. So then they don't suffer the heavy penalty, or they take the risk of going to trial. And you know, and I know, whether you are guilty or you're not makes no difference really at a trial. It is the evidence that is either going to convict you or not, and what kind of jurors you have sitting there. So it seems to me the only way out for somebody who is innocent or says he is, and it turns out that he might be, is to say, like an Alford plea. So I don't have to say I did it. I don't have to commit perjury on the stand. Or I take a quaff and continue without a finding, even though the judge might ask me, is that what happened? And I'm going to say yes. You know, in the probate courts for years, the only way you could get divorced was claiming some sort of one of the 8 or 9 reasons to get divorced, and one of them was cruel and abusive treatment, and that was used most often. And it was done every day in the probate courts, where the woman, usually it was a woman, complaining about her husband. He suffered. I've suffered. My weight has gone down. My blood pressure went up. All of this stuff. And she was lying about it every time she raised her hand. And the husband sometimes did it too. They all lied. And the legislature finally said, well, why do we make people go in that courtroom and lie? Why do we have to get them to lie so they can get divorced? Well, let's do no fault so they don't have to lie. But in our criminal courts, there is no such way to get out from under. If you really didn't do it, but you don't want to risk going to trial and facing the heavy sentence. So I say that to you only because on those occasions where an Alford plea might be suggested, it may be because of that reason, so that we can get through it, get the case over with, and not subject the defendant to a heavy sentence at trial, a bad trial result, but yet resolve the matter, and he's willing to do whatever punishment Your Honor gives him. So I suggest to you that may be a good reason for now for plea. Not that they've done all that much, but there are certain cases where it is important, I think, to do it. So you've been around courts, you've seen judges after sentencing or whatever, they impose probation fees and court fees and every other kind of fee that they can think of. You've seen that, right?
Yes.
Let me ask you, are you going to be the type of judge that waives those foolish fees?
I would like to waive as many fees as possible, particularly if the person is not of means to pay for the probation fees. I don't think they should have to if they're not of means to pay them.
Because most of the time it falls on people that don't really have the ability to pay. And we chase around people that haven't paid fees and fines in this system by issuing warrants, getting police involved to drag them into court. And we spend so much time, it seems to me, on that foolishness, and they don't have the ability to pay, and they're never going to have the ability to pay. So I'd ask you to consider being the compassionate judge I know you were as a prosecutor. And you're not. I think some judges I go before are actually working for the Department of Revenue. And they're really there as agents of the revenue to get every fee and nickel they can out of citizens. So I know you're not going to be that way. So that's all I have for you. Thank you for putting up with me. I think you're going to make a wonderful judge. And I've gotten calls from Judge McAvoy. Who else did I get? I got a bunch of people called you. I know that your list of people that spoke and that recommended you was tremendous. Mike Doolin's the greatest, and people just said great things about you. So have a good career, and remember, the citizens of the Commonwealth are paying for all of our salaries and time. Be good to them, okay?
Much, Counselor.
Thank you, Madam Chair.
Counselor Ionelli.
Thank you very much. I don't have any questions. I had a lengthy conversation with the nominee yesterday. He answered all my questions. I think he's an outstanding candidate. He has the experience. He's a person of compassion. I think he's going to be a great addition to the court. I also received calls from David Eisenstadt, Judge Grasso, as well as Judge Rufo. So when his name becomes before the council, obviously I think it's going to be next week, I'll be more than happy to support your nomination.
Thank you so much, Counselor.
Very much. Counselor Hurley, are you on the line?
I am.
Would you like to ask questions?
I have a couple, and we talked at length the day before yesterday, and obviously reviewing your application, you are a rock star, both criminally and because of the recent experience civilly as well. So I think that you're just going to just slide right in and be a great judge in the Superior Court. I do have one question, however, recollecting, and I forgot to ask you this the other day, but recollecting back to your time at the Dorchester District Court, there was a young judge from the western part of the state that sat there for a week, who learned a lot about the difference in the courts from east to west and how things are done. Did I ever, as Judge Mary Hurley Marks, did I ever have an occasion to have you appear in front of me when you were there as a young DA?
I don't believe so, but it would be shocking if you were there for any period of time and I did not appear in front of you. Do you recall what years that was?
It was 96.
96, I may not have, because I believe in 1996 I had been transferred as a supervisor at the South Boston District Court, and I spent about a year there before I came back to Dorchester as a supervisor in 1997.
Oh, okay. Well, in any event, it was a pleasure talking to you. As I said, you've got a stellar resume, and I didn't get any calls because nobody knows that there is a Western Massachusetts. So But I also concur with the remarks that Councilor Duff made at the beginning of the hearing in terms of whom you may be related to, because you can pick your friends, but you can't pick your relatives. So I intend to vote for you, and I intend to watch your career with great interest, and you're going to do a great job. So thank you.
Thank you very much.
Sierra.
Thank you, Madam Chairwoman. I echo the sentiments of some of my counselors, what they have said earlier. We had a very long, two discussions actually, and I appreciate your service as a district attorney, assistant district attorney over a 30-year span. And I know now you do high-end med mal cases. And the one thing I ask you to remember is that I hope that you're not one of those judges that allow the defense to say that they simply can't try a case for 2 years down the road. So at the end of the day, people are waiting 4, 5, 6 years to get their cases heard, and some of them die during the pendency of these hearings, waiting for trials. So I'm sure you'll keep that in mind. Other than that, yeah, like I said to you on the telephone, I wouldn't vote for you because of who you're related to, and I won't vote against you because of who you're related to. So I think you're a great applicant. In the words of my counselor, Mary Hurley, rock star, she says. But you certainly done it all. The highest end criminal cases and the highest end civil cases. I can't think of a better suited candidate, and you do have my vote next week. Thank you.
Thank you very much, Counselor. I appreciate it.
Thank you, Sophia.
Well, we spent some time together the other day, and you answered all of the questions that I had. We spent about an hour and a half together and talked about a number of things. I don't really have any questions for you. I will say that I think you're probably one of the most outstanding candidates we've ever had here in terms of your experience and qualifications. You've tried countless serious criminal cases. You've tried a great number of civil cases, which is not something we see often. People have usually done one or the other. With respect to your relatives, I've appeared in front of the people, every one of the people that they're referring to on a number of occasions, and 2 out of 3 is not bad. No, I'm only kidding. No, they happen to be great judges, every one of them. I've known them all for a very long time. They do a great job. I think you're going to be better than all of them put together because you're going to learn from them along the way. So I have no issues with your nomination. I think you're an outstanding candidate, and I am absolutely voting for you next week.
Thank you very much, Counselor. I
By the
appreciate
way,
it.
I'm the only one who actually said that. But so other people might be hedging a little bit there, so you might be a little nervous. I just confirmed. I'm in.
Thank you, Counselor. Okay, well, I guess I'll bat sweep up here. Attorney, it really has been a pleasure. We've had several long, detailed conversations, not just about your legal experience, which is remarkable. And as all counselors have said, the depth of your resume is quite impressive and can stand on its own against any applicant. And we thank you for applying. We need folks like you that are capable of making tremendous amounts of money in private service to actually step into public service. And despite what some pundits and people may think, it's very, very difficult work, and the challenges to judges today are much different than they used to be, particularly in the world that we live in. So thank you so much for applying, first of all. And lastly, I think you will serve us well. Thank you for your time today, and your witnesses were outstanding. And with that, I will say this meeting is closed and finished. Thanks so much.
This is